Let's do can we do...
All right, so that wraps up Michael Herman's testimony, and here to discuss with us is criminal defense attorney and former prosecutor David Bruno. He's been watching along. David, first and foremost, I want to go back to that moment that caused the sidebar a little while ago. Prosecutors actually read in front of the jury testimony that had been stricken. That was from the preliminary hearing. It was a little refreshing, the witnesses' recollection, but they read testimony that they shouldn't have read. This jury should not have heard. What are your thoughts about that?
Yeah, absolutely. My initial reaction was mistrial. I would have been on my feet arguing mistrial right then and there. Why? Because it's material to this case. Now, we expect that the medical examiner is going to testify that there was some evidence of strangulation, manual strangulation, but that she died of blunt force trauma. Now, when the police arrived, she was found about 20 feet below her bedroom balcony, which may be consistent with blunt force trauma. We're going to have to hear the ME. But strangulation, to me, would be very, very probative and prejudicial evidence if they could prove it. Now, we got to wait right now, but let's just think. If they got manual strangulation on this victim who later turns out dead, and there's some sort of argument that there's not, or maybe it happened before or by someone else or whatever, this particular prior testimony was right there on the issue of strangulation. So I suspect that it was speculation as one of the parts of the reasons why it was stricken. And if that is the case, and there's an argument that it wasn't manual strangulation, then that is so material to showing that this is a murder other than an accident, and I'd be on my feet arguing for a mistrial.
David, I'm right there with you. I didn't think it was a small mistake. You know, whether it was a mistake is even questionable. I mean, to me, it was a serious transgression. That's probably what they were discussing in the sidebar. And it takes me to my next point, and you hit it right on the head. Really, the sole job of the defense in this case is to convince this jury that there was no intent here to go in and kill this woman, that this was in fact an accident. Again, that's a win in this case for them because it lowers the charge that they'll convict him of.
Without a doubt. She's found 20 feet below her bedroom balcony. Did she fall? Was she pushed? Did he throw her out? Now add the fact of strangulation, and that's a guilty in my mind. If they could show that he had his hands around her neck and was trying to strangle her in conjunction with the blunt force trauma, then you throw in the prior 2 restraining orders, that he was at her house waiting for her. All of these things start to stack up, but manual strangulation doesn't have many defenses or explanations to it. So that prior testimony was right there. How's the roommate know she's being strangled? You know, and that's speculation. That's probably why it was stricken.
Yeah, and that's why they were parsing over those words. All those words, how he described what he heard that night, are all very important to both cases. So that's why they were going through all that. If folks are wondering, there were some folks commenting that they were boring them with that stuff, but at the end of the day, super important to both cases. All right, Dave, stand by. I do have to take a break. Now, after that...